Welcome to the midweek edition of LegalAF. We have the return of the dynamic duo, Michael Popok and my co-host, who I haven't seen in quite some time because of summer and family commitments and all those other things, Karen Friedman Agnifilo. Karen, how are you?
Great. It's so good to be back.
I know.
It's amazing how personal and other commitments get in the way sometimes, but
Summer, but we're so glad you're back. The fall is here. I'm wearing sort of a fall color sport coat for those that are watching this on YouTube and other places, and we are ready to bring the most consequential stories from this week at the intersection of law and politics. We're going to start, Karen and I are going to start with the Department of Justice having accelerated and ramping up their efforts to prosecute Donald Trump and all those around them with not one, not two, but likely three or more grand juries that are in play in Washington, D.C., and we'll talk about what we think each of the grand juries is investigating, and the issuance of 40 or more subpoenas, 40, to everyone in the Trump orbit, including lawyers. And another lawyer enters the Hall of Fame of having his cell phone picked up and reviewed by the FBI and the Department of Justice, having being close to Donald Trump, and that is Boris Epshteyn, and we're going to talk about him as well, that illustrious Hall of Fame that he's entered, another Trump lawyer who's lost his phone to the Department of Justice. We'll talk about what that we think that all means, and Karen, from a prosecutor standpoint, what you think that means. And then we're going to turn to an update on Mar-a-Lago, all things Espionage Act and obstruction of justice, and what is happening in the courtroom of Judge Cannon between the Department of Justice and Donald Trump's lawyers over those pesky 100 classified documents that Donald Trump decided to take as a personal souvenir when he left the White House. And what should a special master look at, and what a special master should not look at, and what it means for a national intelligence assessment about a potential compromise of our national security because the former president decided to have sticky fingers out of the White House and take with him all of these materials that he should have turned back to the government. And then we're going to end with a quick update related to an office near and dear to my co-host's heart, the Manhattan District Attorney's Office, going to trial October 24th against the Trump Organization for tax evasion and fraud and other crimes. And that case is full steam ahead based on the judge's rulings in the last 2 days, and we'll talk about that. Karen, we got a lot to talk about in our midweek edition. Isn't that great?
it's amazing how so much news is made every single day. And, it's just, you almost can't keep up with it. You feel like you're watching a tennis match, right?
Yeah. Ben and I, when we kind of created LegalAF, we literally said to ourselves at one point, is there going to be enough to talk about like every week? In the beginning, just a little bit of origin story. In the beginning, we were filling our plate with things like, let's talk about the World Wrestling Federation lawsuit in Connecticut. Somebody should go back and find the old clips before we realize, you know what, that's not really what our audience is interested in. They're more interested at that amazing intersection to be a witness at the corner or the ringside of what's going on in our democracy as it relates to the all-important justice system. So let's kick it off with what our Department of Justice is doing as it relates to all things Trump. Let's do the head count of how many grand juries we think there are. And then we'll talk about the subpoenas, and we'll talk about the 60-day rule, 60 days before an election, and what the Department of Justice may be trying to do by firing out all these subpoenas at this moment. First, and Ben and I went through this last Saturday, but let me just remind the midweek audience, there's definitely a grand jury in place, federal, led by the Department of Justice, related to the fake electors that Trump and all the people in his orbit tried to use, led by John Eastman, led by Peter Navarro, in order to have these phony electors ready to go to overthrow the government and declare Donald Trump to be the president. That's a no-no in criminal process and constitutional law, and the Department of Justice has a grand jury looking at all things fake elector. We now know, because that same grand jury issued subpoenas related to the Trump PAC, the political action committee that he formed after he lost. Okay, just to make this clear, he didn't have this in existence. This was created special after he lost, allegedly to raise money to fight the big lie, well, what we consider to be the big lie, to fight against the phony election results that Trump and his supporters believe happened, and all the money, millions and millions of dollars that poured in because of those things. So one grand jury is looking at Trump's Save America PAC and fraudulent fundraising using the fake elector scheme together. Another grand jury we know, Karen, is looking at everything that happened on Jan 6th, around the ellipse, how we got there, Jan 3, Jan 4, Jan 5, the command center at the Willard Hotel, Trump's role, Trump's campaign's role, and what happened that led to the attack on the Capitol, right? The siege that was laid on the Capitol, which looks like it was led by Donald Trump and those around him. That's a grand jury. Another grand jury we know is looking at the documents that were retained by Donald Trump, those sticky fingers things we talked about earlier, because they issued a subpoena related to the documents that led us to the search warrant ultimately at Mar-a-Lago. So we know those are all out there. To answer the question, what is Merrick Garland and his Department of Justice doing? This is what he's doing, along with the other 700 prosecutions of the people that stormed the Capitol. So let me first get your view. What's your view of this reporting there, that there is an internal rule at the Department of Justice that 60 days before an election, things that could influence the election by way of prosecution or investigation will be put on hold until after an election? And how do you think that's impacting the issuance of these 40 grand jury subpoenas?
Well, I think it's fairly clear that the Department of Justice is clearly not stopping their investigation, and they're continuing. And this rule or this tradition is something that a lot of criminal prosecutions and prosecutors take very seriously. I know Cy Vance was very conscious of that around the time of elections and would say to us, we can't do anything involving something that could influence an election. And so 60 days isn't really a rule. It's just kind of a place mark that prosecutors give themselves to say, just as you get closer to an election, be careful that you don't make any decisions that could impact that. And so it's just something that's more like a tradition that prosecutors keep in mind. And I think it's clear that this is something that Bill Barr, he issued a memo, and Merrick Garland reissued the memo just to remind prosecutors that they aren't supposed to do anything like that. And of course, we all know that James Comey, when he's felt the need to tell everybody that the Hillary case was reopening 2 days before the election, that a lot of people think that that's why she lost the election. And, so these things have real life consequences. But in this particular case, it's unclear. It's Donald Trump. Does this apply to him? He hasn't declared his candidacy. I mean, clearly he's has an outsized role in the election. He's considered the leader of the Republican Party. But at the same time, does it apply to him? Does it not apply to him? And then the other questions are, does it apply to things that go on behind the scenes, like, issuing subpoenas? The Justice Department won't tell people they issued a subpoena, but the person who receives the subpoena or the lawyers, they are free to tell people. So do you not continue your investigation because there's a possibility that someone else might reveal the information? It becomes very murky when you look at this rule or this tradition and try to figure out how to implement it. I mean, certainly the fact that they seized 2 more phones and issued these 40 subpoenas. I mean, we know of 2 more phones that they seized. For all we know, there were others, because we know DOJ is not releasing this information. These are just people who are coming forward and telling, I think it was the New York Times, about this. And they're the ones who reported on this on Monday. But I really think that it's very clear that DOJ has not gone on vacation and they're not pressing pause. I don't think they'll make an arrest, for example, during the 60 days, those types of things. But I do think their investigation is clearly continuing. And, interestingly, the New York Times article that reported about the fact that these phones were seized and these 40 subpoenas were being issued. Normally, if the New York Times had a copy of the subpoena, they did talk about what it was subpoenaing, but they didn't mention the crimes that were being, or which statutes were being investigated. At least I didn't see that. And so I found that interesting because that led me to think maybe they haven't seen a copy of the subpoena. Maybe someone just told them about the existence and what they were looking for, which were documents and records. But so I'd love to know which of the crimes of the 4 grand jury investigations that you just mentioned are these subpoenas, because although there are these separate and distinct investigations that you just laid out so perfectly about what's going on, in reality, they all bleed together. So if you're a prosecutor prosecuting this, for example, you might want to prosecute Christina Bobb, the lawyer who I believe is the one who swore the affidavit saying, I searched and found all the documents and there's nothing else in there, or whatever she said. But let's say they prosecute her and she has lawyered up. Let's say they prosecute her, she could flip. I don't know if she would or not, but let's say she flips and cooperates. She could cooperate on the Jan 6 investigation because she was in the room in the various rooms. I think she was at the Willard Hotel. She was very much involved in a lot of the planning, or she could be involved in the fake elector scheme. Who knows? So to the extent, it's one thing to look at these things as separate, but as they go up the chain in particular, these investigations are going to start to bleed together in ways that I think these are going to be these are going to start coming together nicely if things go the way I predict they're going to go, which is towards additional prosecutions.
So yeah, that's a good observation, especially about the 60-day rule. I think that's from your prosecutor standpoint to hear that. And I agree with you. I don't think, since he's not a candidate and he hasn't announced and may not announce, I don't think it necessarily applies to him. And certainly what we've seen from the Department of Justice is it's full steam ahead. I don't think they're trying to cram things in before this imaginary 60-day period. I think they are just moving forward with their investigation with the grand jury. And that was very good observation also about, we learn this information that we're piecing together on this podcast and in other places because people reveal it to the papers and others, not because the Department of Justice is leaking it. And so what we know, though, from people that have decided to disclose what's happened to them, that Boris Epshteyn, who is a lawyer, who was a very close confidant, friend, and fundraiser for Donald Trump, got his phone picked up. So we've got at least 3 lawyers, if not more, probably more, half a dozen lawyers who have had their phones picked up. Rudy Giuliani, of course, had all of his devices at one point picked up. So, if you're going to represent Donald Trump, your law license is at risk, and your phone is probably going to get picked up in a criminal investigation. So what's on that phone related, we think, to the fake elector scandal, because both Boris Epshteyn, a target of or at least a recipient of a subpoena, and Mike Roman, who was Trump's head of election day operations, worked together on what we call the fake elector scheme. So we think that's coming out of the fake elector / Save America Pact grand jury. Then you have, of the remaining 40 that it looks like have gone out, subpoenas that have gone out, it looks like it's broken down again into fake electors, Save America Pact, based on the information that's been requested. Maybe not the statutes that have been cited, but the information is a lot about the PAC and the phony fundraising, and a lot about the fake electors. So we get a sense that's coming out of that one grand jury. So you have Dan Scavino, we know, who was the social media director. I think he used to actually, he was in charge of I'm not making this up, the golf carts at one of the Trump properties before he got promoted to be head of social media for Donald Trump. But Dan Scavino, close confidant Donald Trump, got a subpoena. Bernie Kerik, the disgraced former police commissioner from New York, who also testified to the Jan 6 committee and is a very close confidant of Rudy Giuliani and promoted the big lie and the fake electors. He's been subpoenaed again to the grand jury. So, and we know all the other ones that have already gone in. I mean, there's a lot of low-level White House aides who know the most, right? They're the literal fly on the wall in every meeting, and they don't want to blow their careers or go to jail. So they're inclined to tell the truth. They covering up for the president is not part of their resume, resume building. So the low-level executives, low-level aides are going to be very, very helpful here. And then the senior most people. So a good development. Now let's manage some expectations here. If I had to predict, and I want to get your view on it, the Fulton County, Fani Willis grand jury criminal prosecution is further ahead than the Department of Justice with all of these grand juries. Do you agree with me on that?
It certainly appears to be, yes.
Yeah. And I think the Department of Justice is also all these grand juries is also necessarily behind what's happening in a more rapid basis in the Mar-a-Lago criminal investigation. Do you agree with that?
Based on what's been publicly reported, yes, it appears to be, but it's hard to know. I just having been on the other side of it, where you get all the speculation and reporting on something, and meanwhile, we would know what was really happening. Sometimes you scratch your head and think, where are they getting this information from? And gee, they really don't know, but I can't say. But it also was comforting as a prosecutor because it showed we didn't have leaks,
Yeah,
so
right. No,
yeah.
I'm not doing leaks. I'm just saying, based on how it looks, the case is developing in court. I just want to manage expectations. Department of Justice, is a giant bear that got out of hibernation and is now wandering around looking for food. Boy, I'm really into a fall-winter mode. But it's going to take a while. One of the things I know from the reporting that is part of the subpoenas, Karen, is not only what we've already talked about, but is also give us all of the stuff that you gave to the Jan 6 committee. So this is now the Department of Justice playing catch up.
Because they were asleep for 2021.
Yeah, and the Jan 6 committee, to its credit or its detriment, wasn't willing to turn over its materials until they were done using them for their own purposes. So they kind of kept the Department of Justice and the FBI a little bit at bay. And we know there was a fight over that. But now the Department of Justice is playing catch up. Good developments if you're in favor of justice and bringing Donald Trump to justice. But the wheels of justice move slowly, but they grind really fine. That's what we're watching now.
Before you move on, I just want to mention something about Bernie Kerik. I always forget that he's caught up in this soup of Donald Trump world. And for people who aren't from New York, Bernie Kerik was a larger than life character here back in the days when Rudy Giuliani was the Southern District U.S. Attorney and then America's mayor during 9/11. Bernie Kerik was the corrections commissioner. And, there's a big, he's on the local Manhattan jail. It's the Bernie Kerik Correctional Facility. I mean, he's sort of a larger than life figure who
he may end up there.
Well, so that's what I wanted to say was, so he had a big falling from grace and was prosecuted and was put in prison for many years. And he is a perfect target for the Department of Justice. He is the kind of guy that they are going to go after and really try to flip because he's vulnerable because of his prior. First of all, he's been to prison, so he doesn't want to go back. He knows how bad it is. And second of all, any sentencing of him, there would be an enhancement because of his prior criminal conviction. So I think he's just so as a result, he has more to lose. And those are the types of things that prosecutors look for when they're looking to find someone who potentially might flip, is who has the most exposure, who has the most to lose. And he's somebody that I think we should keep our eyes open to see. I could see the prosecution heating up against him.
Yeah, even more. Very good observation on that. Let's move on to catching our listeners and followers up with Mar-a-Lago. So we have Judge Cannon, who we already reported on, has made her initial ruling, that she would appoint a special master, and she would have that special master review executive privilege material, attorney-client privilege material, and personal items of Donald Trump, sort and sift through all of that, and then report back to the judge and ultimately to the parties, basically granting everything that Donald Trump wanted. We now fast forward to the Department of Justice's response to that, which was appealing aspects of the order, not the entire order. We'll talk about the aspects of the order the Department of Justice was okay to live with, was okay to swallow, related to that, so as not to delay the prosecution, the criminal investigation, and the intelligence assessment about whether our national security has been compromised by Donald Trump storing hundreds of classified documents in a storage room or other places at Mar-a-Lago, and a very not secure facility. So the Department of Justice has gone back to the judge and said, we've appealed you, Judge. As to the aspect of your order that stops us in what we call issues an injunction against the Department of Justice using the materials until they're reviewed by the special master, including the classified materials that are obviously marked classified, in their continuing investigation, meaning you can't use it to go talk to witnesses with, you can't follow up with them. It stops the Department of Justice down in their tracks related to those 100 classified documents. And also, by extension, the way the Department of Justice reads the judge's order stops the intelligence community, including the FBI and the Director of National Security, National Intelligence, from reviewing the documents also. And so they are appealing that. And they're also appealing the aspect of the magistrate, the order of the judge to set up a special master to establish or look at executive privilege, arguing there cannot be any executive privilege. And therefore, having a special master look for executive privilege is a fool's folly and is unconstitutional. And they told the judge last week, we'll give you till the 15th of September to fix your order as it relates to those things. Here's what the Department of Justice is willing to live with, Your Honor. You can have a special master appointed. You can have them look at attorney-client privilege material, if that's even in existence, and he can pick out, or she can pick out, any personal items like medical records or passports, or anything that's sort of a personal item, not necessarily the focus of the investigation. We're okay with that. And the judge has not yet ruled on that issue. I don't want any confusion in the reporting. People are like, oh, they've agreed to the special master. They've agreed to the special master concept, but only in the limited way that we've just described. Then the judge gave Donald Trump and his lawyers the ability to file their paper addressing what was a motion for stay, the Department of Justice going to the trial judge saying, you need to stay these aspects of your order, or we're going to have to go to the 11th Circuit and get an appellate stay against you for that, because we got to move the investigation forward. It's irreparable harm to the nation if we don't, and we've got to do the intelligence assessment. And we haven't gotten that ruling yet. What there seems to be agreement now on, and Karen, I want to get your view on this, is who's going to be the special master. The Department of Justice put up two former judges, very highly reviewed and rated, Barbara Jones, who has done this exact work in the Michael Cohen case, in the Rudy Giuliani case, and another judge, Griffin, who's the formerly on the appellate court for the District of Columbia Federal. The other side, Trump put up a federal judge, Ray Deary, we'll talk about him in a minute, and Paul Huck Jr., who I know in the community is not really the person for this job, especially since he's married to a woman a judge who sits on the 11th Circuit, Barbara Lagoa, who was also touted to be on Trump's short list for the Supreme Court before he picked Amy Coney Barrett. Not the right person. And I said last week with Ben on the weekend that they obviously put up Paul Huck Jr. because at least Trump wanted Ray Deary to be picked, and they were sort of pointing the arrow at Ray Deary. And the government has agreed that if they want Ray Deary, they're okay with Barbara Jones, Judge Griffith, or Ray Deary from the Eastern District of New York in Brooklyn, who's on senior status or maybe coming off of senior status, and has the background, having been 9 years on the FISA court for foreign intelligence surveillance, appointed by Chief Justice Roberts, that he's okay with the Department of Justice if the special master is limited to the things that we just said. They also filed and said, on a very interesting note, the Department of Justice filed last night and said, we don't really understand Donald Trump's argument. How could anything be both personal to him and covered by the executive privilege? If it's personal to him, and we'll talk about how classified material could ever be personal to a president, an ex-president, then how do you have it be covered by your presidential title and status with an executive privilege? It's either personal or it's presidential. If it's presidential, then you get the executive privilege. So we don't get that argument. And also, how could classified material ever be designated to be personal? And where the Department of Justice wrote last night, where is a declaration or affidavit from Donald Trump that says any of that, that says that he's declassified any of this information? That's only been reporting. That hasn't been a declaration by the ex-president, or that this is personal to him and how. They don't file anything related to these things from Donald Trump. They never put Donald Trump in harm's way with an affidavit or a declaration or any sworn testimony or evidence related to it. They just say it, just naked arguments of counsel in their filings or in the courtroom. So that's where we are, and that's what's all on the slender shoulders of this very junior judge, Judge Cannon, to have to make this ruling in the next few days or be taken up on all these issues to the 11th Circuit. Let's start with the special master. What did you think about the Ray Deary selection consensus between Department of Justice and Donald Trump?
I mean, I think anyone who doesn't think that there's a 100% chance that Ray Deary is going to be the special master doesn't know what it's so clear that he's going to be the special master, right? He's very well respected. I mean, he was a very well-respected judge. Everyone who's appeared before him will say he's a fair, smart judge who recently took senior status. He has staff in place that can jump to do this very quickly. He was on the FISA court, as you said. I think I haven't found, although I've never appeared before him, I asked around about him. I know Barbara Jones very well. She's excellent. But the fact that they all agree on Deary means that is 100% who's going to be picked. I mean, there's no question in my mind about that.
There's only one problem with Deary, but the Department of Justice has obviously calculated it and think it's not a problem, is that, he was involved with the Carter Page FISA subpoenas, search warrants. He authorized 3 of them, and subsequently 2 were found to be invalid based on misinformation by the FBI. So if Ray Deary felt like he was misled by the FBI, I assume that's why Trump picked him. They figured they had to pick a federal judge. Let's pick one who once got burned by the FBI. But given his body of work. Yeah,
exactly. Of all the years of not being burned by the FBI, I don't think he's going to, I think that's a little bit of a stretch to think that one negative experience is going to cause him to suddenly lose his judgment of all these years. So I think he's clearly going to be the special master. I have a slightly different take on this whole special master thing. It feels very much like a red herring. I mean, I hate to use I think that's what Bill Barr said, but it really sort of does. I think the Department of Justice did an excellent job at threading the needle here and say, fine, you want a special master, have a special master, just not for these particular documents that we have to go through so that we can assess both the national security implications as well as continue on our criminal investigation, and I think that the interesting part about this that the Department of Justice pointed out was that there really is this bleeding together or blending together of the intelligence community and the law enforcement community in this particular instance, that you can't separate them out. You can't sort of say, okay, we'll use because the judge's order says you can continue to use the classified documents to assess the national security implications, just not for any criminal investigation. And I think that shows, and the Department of Justice did a good job at letting them see that it shows that that they really don't know really doesn't know what she's talking about by thinking that these things are separate, because the intelligence community, they can't conduct investigations into domestic criminal activity, and to assess. So for example, to me, like the best example is these empty files, right? There's these empty folders that were marked classified. Somebody's got to figure out what was in them and who took them and where did they put them, and how are they going to do that without things like subpoena power or using search warrants? Those are all domestic law enforcement techniques, and that's the only way they're going to figure stuff like that out. And so there is really no, and the CIA can't do that, right? Only the FBI can do that. So there really is no way to separate this out. And I think the Department of Justice explained that in their response, and is giving the judge an opportunity to change course here. But part of me wonders if she doesn't do it, let's say she doesn't agree to the partial stay. Should they just agree to the special master? And this is where my take is a little bit different. Should they really appeal, or because to me, that's going to delay things even more. I think that if they go to the 11th Circuit, then they're really going to be a delay. And then at a certain point, their argument that there's a national security issue, I think, falls. Maybe they instead just go along with the special master. I think Judge Deary is a serious person, and I think he will I could see the special master sitting down with all these documents and saying, I'm going to start with the things that are marked classified. And he can look at them and easily say, they are not personal, as you just pointed out. Right. They are not attorney-client, because they, by their very nature, cannot be attorney-client. They are not executive privilege, because the law doesn't apply there. And the Donald Trump and your team, you haven't put forth any evidence that these things are declassified. And so therefore, I am now on day one handing them over to the government to say, government, you can now review these, while I now parse through the, is this or is this not a presidential record? Is this personal? Is this, your medical records, your tax records, all the things he claims that were stolen? That might take a little bit longer. I don't really see it. But like I said, this is where I'm a little bit, I really think that if the judge does not, I think the judge might, to save face, give the DOJ what they asked for here and say, fine, you can do this. But if she doesn't, I think it'll be interesting to see whether they choose the appellate route that will delay this, and or are they just going to say, fine, let's just do the special master and go forward.
I think that's an excellent, amazing observation that I haven't heard before. Comes from your years of being a prosecutor. I think you're right. I think the path of least resistance here, the quickest connection between the Department of Justice and what they want to accomplish, is to stay in the West Palm Beach courthouse with Judge Cannon, try to shape the result, as you just eloquently outlined, all those points, try to shape the result that they can live with, right? We always say that that perfection is the enemy of the good, or the good enough. It doesn't have to be perfect, but is it good enough for the government to accept so that they can accomplish in a expedited fashion all the things they want to accomplish, progress the criminal investigation, and do the national intelligence assessment? And I think you're right. I think they stay, if your analysis is dead on, you stay in the West Palm Beach courthouse, federal courthouse, if that's what you want to accomplish. Otherwise, you run up 95 to Atlanta to go hang out with the 11th Circuit and spin the wheel there and find out which 2 out of 3 Trump appointees do you get on your panel, and therefore your chances of a stay are diminished as well with all the briefing that's required.
I have one more thing I want to say, if you don't mind. Yeah. I apologize, but
I don't.
I know. Sorry. Okay, just one more quick thing. There's something in this that so Donald Trump's team on September 12th, which was a couple days ago, filed the response to the Justice Department's motion for a partial stay pending appeal, right? And you read it, and it's sort of, he says that this is unprecedented, misguided, at its core, this is a document storage dispute that spiraled out of control, all that kind of stuff. There was something in there that caught my attention, though, that I want to bring up, that I want to just hear what you have to say, or let's keep an eye on. And it's footnote 1. So in footnote 1, he basically says that, they don't exactly say this, but I'm taking it 2 steps further. But he basically talks about is, if these are really classified documents, if this was a real criminal investigation, when you have a criminal investigation, you have to be prepared at some point to go to trial, right? At some point you're going to trial. It means your evidence gets put before a jury. And so what they're saying is, if this was a real criminal investigation, the DOJ must have already made the determination that these classified documents are something that you can release to a jury, because if not, you wouldn't even have a criminal investigation. And so it was sort of interesting to me, because it makes me wonder, is this really a real criminal investigation? Because I don't think at the end of the day, if this was really the nuclear secrets of other countries, there's no way this is going to be put into evidence. And so I worry a little bit that, is this really a criminal investigation, or does the DOJ want delay in this matter while they do their real criminal investigation, which is the Jan 6? Because to me, that is the one that has, like, that, or the fake elector, Phony Willis, but the DOJ version of it. To me, those are the real cases that you can't say it was a witch hunt. You can't say this was a document storage. Those are the real criminal cases that I think that won't cause riots in the street, because those really happen. So I don't know. Part of me kind of wonders, does the DOJ really want this to proceed quickly? Because I don't know that this is a real criminal investigation, because at the end of the day, I don't know that they would be prepared to put these records into evidence at a trial and have them be out there for the world to see.
Yeah, that's a good observation. I mean, one of the things we'll have to look at is when they've tried espionage cases in the past, all the way back to like the Rosenbergs, when they have nuclear secrets and other things, I assume there's a way to, even though the preference and the rules require public disclosure of things, there has to be scenarios where you try a case, but things are sealed, and other people than the jury are banned from the courtroom, and information can be presented in a sealed container because they are still active, live, radioactive documents. Otherwise, you'd never be able to prosecute somebody for stealing a national secret because you didn't want to reveal the national secret.
No, right? There are all kinds of rules in place and laws that govern this. I think it's called SEPA. I think is the acronym for these types of documents. And I'm gonna, between now and next week, I'm gonna bone up on this and we'll talk about it and see what it is. I still think, though, I know it's very complicated. And I do think it's complicated both actually, but also from a public, perception standpoint. The whole Russia collusion, that whole thing that was done before really didn't get anywhere and didn't win over the hearts and minds of the American people. And I think they have to be careful, because it just feeds into his witch hunt language. They have to be careful if they're going to do the unprecedented thing, which is prosecute a president of the United States. They got to put their best foot forward. And I don't see them doing it on just this. I really don't. And so I think that delay might be something they actually want while they go forward on their more serious cases. That's what I think this Department of Justice might be doing.
Yeah. Well, that's a good segue from our discussion about which of these prosecutions is further ahead and why, and this chess game that prosecutors, not all in the same office or even in the same system, federal versus state, are playing throughout this, and why. And we talked a lot about, Karen, special masters. They're supposed to be neutral, but when it comes to saving the planet, there is no neutrality. And if you keep your money in most standard bank accounts, they're lending your deposits out to fund oil and coal, fossil fuels. Switch to the Planet side and get Aspiration. It's a new debit card we're going to talk about. Aspiration is a climate-friendly alternative to big banks. Get an account and a debit card that's built to help your wallet and the planet. Moving $1,000 to an Aspiration Plus account has the same impact as driving 6,000 miles less a year. Plus, you can earn up to 71 times as much interest than at your old bank. Aspiration is fossil fuel free and lets you plant a tree by rounding up every swipe of that debit card. Aspiration's been hard at work helping people align their money with their values about the environment, funding the planting of over 100 million trees, on their way to funding the planting of 1 billion trees by 2030. It's no wonder why Forbes, NerdWallet, and the Penny Hoarder recommend Aspiration for the eco-conscious. I have always wanted to find ways to reduce my carbon footprint and to help the environment. And here's a great way. I care about fighting that climate change because of this. And now I love how easy Aspiration allows me to do it. Best of all, there's no credit check, no overdraft fees. And with Aspiration, you just pay what you think is fair, even if that's zero, because money shouldn't stand in the way of doing the right thing. Make your dollars a difference. Open an Aspiration account at aspiration.com/legalafdebit, DEBIT. That's LegalAF debit, and move your money out of fossil fuels. Help save the planet with your Aspiration debit card. Open your account at aspiration.com/legalaf debit. That's one word, LEGALAFDEBIT today. That's aspiration.com/legalaf debit. Terms and conditions apply.
I love this card.
I love that card. Me too.
I do too.
I love that sponsor.
Yeah, I do too.
It does align with the values of our listeners and followers and our show. And I'm so proud to have them as a sponsor. Let's move quickly to, everybody knows I'm trying to catch a plane. Let's move quickly to an update on a case being prosecuted by your old employer, your old bosses, where you were the number 2 at the Manhattan DA's office against the Trump Organization. Everybody forgets there's a criminal case against the Trump Organization. Who are the owners and executives of the Trump Organization? Let me think. Donald Trump and all of his children. And we've already reported that 3 weeks or so ago, Alan Weisselberg, the longtime 30-year plus CFO, Chief Financial Officer of the Trump Organization, who is also facing 15 counts of tax fraud and tax evasion, pled guilty. And if he wants his 5 months sentencing, even though it's in Rikers Island, which is a terrible place to spend 5 months, I wouldn't want to spend 5 minutes in Rikers Island. But if he wants that 5 months, he's got to testify truthfully about the conspiracy that he organized and led and all the people of the Trump Organization that knew about it. So we're going to have to see what happens to him. I don't take a lot of comfort. I take some cold comfort from the reporting that as soon as he made that deal and pled guilty, the Trumps threw a birthday party for him at one of the Trump buildings. It doesn't sound great to me, but in any event, Trump Organization goes to trial October 24th. Judge Marchand, who's also the judge for the new Bannon trial. Boy, is this like all things coming together. Same judge now handling the Bannon indictment and surrender and all of that, and trial there about Build the Wall, has been the judge all this time on the Trump Organization prosecution by the Manhattan DA's office. And what did we learn last week in some of these last hearings leading to October 24th about whether the trial is going forward and the types of defenses that the judge will or will not allow, Karen?
So Judge Marchand is someone I've appeared before many, 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 many times. He's a great judge. He's calm, he's kind, he's fair, he's very judge-like. And he said in his calm way, October 24th is a fixed date, and that's that. And the Trump lawyers tried to get a delay. They appeared before Judge Merchan last week and basically asked for motions in limine and talked about various things. And one of the things that the Trump org's lawyer, Susan Necheles, she asked for more time because she says that their defense is changing now that they have the Alan Weisselberg testimony. And Judge Merchan said, no, this is a fixed date and you're going forward on October 24th. Two things I want to say. Susan Necheles is a real lawyer. She's not, Trump hasn't been able to attract good lawyers or real lawyers yet. But Susan Necheles is a respected attorney in this area. So I found that sort of interesting that she is representing the Trump organization. And the only other thing I want to send out something to watch is what exactly is Alan Weisselberg going to say? And what will he say when he's called as a witness? Because I think he's going to not implicate the Trumps. And as a result, I think that's going to make any future prosecution of Donald Trump by the Manhattan DA's office very, very tricky and very precarious. And I think that's, it's going to be interesting to see how that plays out.
Well, Susan Necheles, the lawyer that you just mentioned, certainly signaled that, because when she gave her mandatory courthouse steps interview press conference afterwards, she said, oh, this is going to be about Alan Weisselberg and one other person that, he's going to testify that nobody knew about this scheme. And it was just him and one other guy, the Trump organization. That's not a criminal prosecution of an organization. Now, look, I've defended organizations in criminal cases, and I know you have too. There are many ways up that mountain to find that a organization has criminal liability if one of its senior executives for many, many years, without oversight, without supervision proper, without controls in place by the organization, without compliance around it, you can still prosecute the Trump organization. But you're right, if people think that Donald Trump or his children are going to be criminally found liable in this trial, that's A, unlikely, and B, that's not who's the target of the criminal case.
Not this trial, but I also think in other future prosecutions. Think about it. Alan Weisselberg is going to be called as a witness by the Manhattan DA's office. That means that he's their witness. They're going to put him on direct. They're going to ask him questions under oath. And in some ways it means they're endorsing what he says. And, frankly, if he says Trump and his children weren't involved, that creates Brady material, which is exculpatory material. It makes it very hard if you have under oath exculpatory material that you created to then use that in a future prosecution of Trump. To me, this is in some ways potentially the final nail in the coffin of the Trump prosecution that I always hoped and hope is not dead. Because, Alvin Bragg has said it's not dead. So I keep hoping that it's not. But this worries me that this could potentially impact that in the future.
Although the nature of the case, it's an interesting case. And anytime you can talk about Trump organization and criminal prosecution in the same breath, I get excited, you get excited. But it's a case about whether, a bunch of executives off the books got, private school paid for, limos, cars, and apartments paid for. It's interesting, but, is that the thing that's going to send Donald Trump and his children to jail for life? No. We've got bigger fish here to fry. I want the prosecutor's office to do their job, and they're doing it. I want them to, if there was a bigger case against Donald Trump, led by the special prosecutor team that exited, I wanted them to do that too. But at the end of the day, this case is small potatoes compared to all the other cases that are going on against Donald Trump that could fell him. But let's keep an eye on it. There's going to be a little bit more hand-to-hand combat between now and October 24th. The judge asked for some other motions to be filed, and you and I will follow them. Karen, I'm so happy to have you back.
I'm happy to be back. I hope you catch your plane, Popok.
I know. I hope so. I hope my co-anchor didn't torpedo me.
Okay, goodbye. Let's get off the phone.
It's all right. It's fun. it's just part of the job. We're practicing lawyers. We're on the road. I'm in Las Vegas doing depositions in a case. What are you going to do?
Wow.
Anyway, shout out to the Midas Mighty. Shout out to all those on LegalAF who follow our Saturday show with Ben Mysalis and me, and our midweek edition with Karen Friedman Agnifilo. We are on the forefront of providing you with information that you need in order to make critical decisions in your own life and to debate your friends and family about what's really going on in our court system as it relates to the political world. And we'll see you next week on LegalAF.